Hi, I'm Sarah Greengrass, and I work at the U.S. Consulate General Chennai as an economic and political counsel. I also have a legal background. Today, you're watching part of a three-part series on the U.S. Constitution. This is our second video in this series. In this video, Consul for Public Diplomacy and Public Affairs, Lauren Lovelace, is having a conversation with Madras High Court advocate Suhrith Parthasarthy on the evolution of the First Amendment and the values it protects.
I'm so delighted that you're here, Suhrith, here at the American Center.
It's my great pleasure to be here. Thank you. Thanks for having me.
We couldn't think of anybody better to talk with us about the First Amendment and freedom of expression. As you can see, I took the liberty of taking our preamble from the Constitution from the National Archives in Washington, D.C., bringing it with us here. The Constitution was developed, of course, and then after that came the Bill of Rights. And the first amendment is the First Amendment, for which concerns freedom of speech, freedom of expression, and other things. Can you give us a little bit of a feel for the scope, what you feel to be the scope of that amendment?
Yeah. So the First Amendment was a part of the Bill of Rights, as you said, which was a part of 10 different amendments that were made to the American Constitution. It was brought into force in 1791. And it was really sort of a give and take between the Federalists and the AntiFederalists in many senses, because the AntiFederalists clearly believed that there should be greater protection of individual liberties, that government shouldn't be too powerful, and that the federal government especially shouldn't be able to impinge on many of the basic rights and liberties of American citizens in the different states.
That's right.
So it was a give and take between them, and ultimately, the fact that the Bill of Rights was really seen as something which would allow many of the states to sign on to the American Constitution. And the First Amendment, as you say, was obviously the first of these various rights that are contained in the Bill of Rights, and it protects, among other things, against governmental interference in the free exercise of religion. Right. It prohibits government from establishing religion.
Right, the Establishment Clause.
The Establishment Clause. And then it obviously prohibits government from preventing the free exercise of speech, from preventing the freedom of assembly, right, as well as the freedom of the press.
Right.
So I was just thinking that possibly over the course of our discussion, given the limited time that we have, we'll possibly go over essentially issues of free speech and freedom of the press, as opposed to concentrating on the freedom of religion and the Establishment Clause, which might make it way too broad, and we might need a whole hour.
Those are future videos.
Future videos,
yeah,
right. Certainly. Yeah.
So you mentioned the Federalists and the AntiFederalists, with the AntiFederalists being led by a fellow named Patrick Henry back in the 18th century. And their concern was this overarching, put in the time that they were in, this sort of colonial rule from the top, and they were looking for states to have more power. And I guess, as you said, and you put it really nicely, they required the Bill of Rights, right, in order to go forward with the rest of the Constitution, because otherwise they thought they would have a federalist system that would not allow for state power.
Yeah, and I suppose in many ways this is not today a battle between Federalists and Anti-Federalists in the sense it was in the 1790s and the early 1800s, but the battle remains, right, in many senses, in the sense of should the federal government be as powerful, or should there be greater, leeway given to the state governments? Where should the real experimentation happen, and so on and so forth?
So even with the First Amendment, the way that it's phrased, Congress shall pass no law, it's very much focused on the federal government, but over time that has been construed by different courts, including the U.S. Supreme Court, as pertaining also to state government.
Certainly, yes.
But not to private businesses.
To private. Yeah, so the Constitution as such is broadly enforceable vertically. That is, there's a vertical relationship between the state and the citizen, and although it does govern relationships between citizens by virtue of sort of governing the relationship between the state and the center, broadly it defines the relationship between the state and the citizen, as opposed to inter se between private interests.
So let's think about the values, the specific values. I mean, you talked about the scope of the different clauses, but looking at specifically the values that the First Amendment seeks to protect vis-a-vis freedom of speech and freedom of expression. Right. we have some great American, Oliver Wendell Holmes and Learned Hand and others who have come up with or have issued decisions that have really guided us for so many years in American jurisprudence. Can you talk about what the values are, and specifically this idea of how content of a message or content of a written or spoken statement is harder to limit. It's harder to. The U.S. Supreme Court has made a distinction between regulations that limit the content of a statement and those that neutrally limit time, place, and manner.
Yeah. So, to begin with, to answer the first sort of limb of your question, which is on the values of free speech as protected by the American Constitution, there are essentially two ways that you can look at this, right? You either look at it instrumentally or intrinsically. And what I mean by that is, by instrumental values, what I mean is that free speech is necessary because it is important to preserve other values, such as democracy or the peace and other such values. So unless we're allowed to speak freely, democracy won't thrive. That is, in order for a country to be truly democratic, we need its citizens to be able to speak their minds freely. The other way of looking at it is intrinsically. That is, each of us as equal citizens have a right to exercise our speech freely because each of us has equal moral membership in society. So if you look at the history of the framing of the First Amendment itself, given this sort of battle between the Federalists and the Anti-Federalists,
right,
it perhaps had certain instrumental values right at the beginning, because it was thought that the states should, not be impinged upon in any way by the federal government, and that citizens should continue to be able to exercise their rights freely. But I think over a period of time, especially with the way in which the First Amendment has been interpreted by the Supreme Court especially, and by the various different courts, we've seen that free speech tends to have a lot of intrinsic value in America, and it's seen as something which is a core liberty which requires protection at any cost. And that it's not necessarily only instrumental in the sense of it being necessary to preserve democracy, but that each citizen has that right by virtue of them being American citizens. And I think the values itself sort of are undergirded by the interpretation that the Supreme Court has given to this, and we can look at some of that if we start, going back to the 1790s itself once again, and if you look at the various different legislation that were brought about to the stage, and which again was a battle between the Federalists and the Anti-Federalists in some senses.
Like the Sedition Act.
Yeah, like the Alien and Sedition laws, which Madison was...
James Madison, our fourth president of the United States.
Right, your fourth president. He was vehemently opposed to the sedition laws because he believed that it directly impinged on a person's right to freedom of speech. And John Adams famously lost power to the support that he lent to the law. But the validity of the law itself was not something which was considered until the early 1900s.
That's right.
When on the back of, during the First World War, when there was a lot of protest and opposition to the drafting that was taking place.
That's right. And drafts, just to explain in case people don't know, draft is a requirement to serve in the military by a government. So we've had that on a few occasions.
Right. So there were a number of landmark judgments that emanated out of this period, which included largely prosecutions that were made under the Espionage Act, which involved acts of seditious libel or of different kinds of sedition, where people were essentially prosecuted for merely urging against drafting.
Right.
It was just mere speech urging against drafting, or it was merely the distribution of pamphlets, anti-war pamphlets. And there were two judgments of the Supreme Court which are critical from this stage. One is Schenck versus United States, and the other is Abrams versus the US. And they're important because in Schenck,
which is 1919.
Right. And Schenck is critical because this is when, as you mentioned, Justice Oliver Wendell Holmes, he propounded this theory of clear and present danger, where the idea was that speech should have a proximate link to the prohibition or to the thwarting of a legitimate act of government. Mm-hmm. And he felt that the act of preventing espionage was a legitimate act of government, but so long as speech had a direct and clear and present danger to the threat of preventing that, then the government was justified in prohibiting and prosecuting that kind of speech. But in Abrams, which was a judgment which was delivered by the Supreme Court against 7-2, Justice Holmes dissented. And this was a case where a person was merely prosecuted for throwing out pamphlets from his window. And Holmes applied his own test in Schenck of clear and present danger. And he said that this test would mean that this is not a prosecutable act. But it was unfortunately, or at least he was sort of speaking to the intelligence of a future day, to use his own words, and it was a dissenting opinion as opposed to an opinion that formed part of the majority.
So the clear and present danger test, which is also sometimes known as the false cry of fire in a theater test, that's 100 years old now, 1919. Now here we are in 2019. How has that decision, the clear and present danger, changed over time?
It isn't applied anymore. It hasn't been applied since 1969, when in Brandenburg versus Ohio, a unanimous Supreme Court sort of changed or reversed this test of clear and present danger to one of an imminent lawless action, where they wanted a more direct link between speech and at the least a potential to create violence or to lead to a violent action. And this was a case where during a Ku Klux Klan rally, the leader of the group was prosecuted under the Ohio syndication law, which was a law which essentially prohibited any kind of speech which needn't necessarily have incited hatred, but was merely sort of advocating hatred of some sort. And the court struck down this law as unconstitutional and as violating the First Amendment because it believed that there has to be an imminent link between the speech and the act of violence. That a mere sort of protest march, as hateful as it might be, has to be still protected under the protection of free speech given by the First Amendment.
And let's move now to a topic that would, I think, be very relevant today, and that's the conversation about hate speech. And, should hate speech be an exception to free speech? And I'm thinking about hate speech as we've known it, even constitutional in constitutional decisions. But also, I'm thinking now in today's context about trolling or online hate speech and thoughts on that.
Right. Well, this is. I think free speech has universal values, but at the same time, this is one of these global debates, right? Because America traditionally tends to protect even hate speech, or at least that's the common notion. Whereas in Europe, there are laws across Europe which prohibit hate speech, and there are a number of prosecutions that are committed for hate speech. And in India as well, we have laws that prohibit hate speech. But if you look at Europe, for example, any racially charged speech, whether it's actually incites violence or not, is prosecutable. Whereas in America, by virtue of the test in Brandenburg versus Ohio, it's unless there's a direct link between the speech and a potential threat to violence.
That's right. Because otherwise the thought is that speak louder, be the voice of reason that is speaking louder. Right. And
so the idea is that more speech is better. The best way to kind of get over hate speech is through more speech, as opposed to prohibiting that speech. We're very pro-speech. But I'll also say this. I mean, there's this idea that the American First Amendment is absolute and that it kind of preserves every form of speech. But I think that this is a misconception. And there's a famous article that was written by your former Supreme Court Judge John Paul Stevens.
Yes.
I think sometime in the early 1900s, 1993. Where he speaks about how the First Amendment specifically uses the word "the," where it says that there shall be no laws made by the government which abridges the freedom of speech and not abridges freedom of speech. So which means there is a certain form of speech which the framers had in mind when they were drafting this clause, and not any kind of speech, because he points to the example of defamatory speech. Or of speech or of lying under oath.
Yes.
You can't say that is protected speech, or of malicious advertisements. Those are not protected forms of speech. So clearly the American Constitution preserves certain kinds of speech.
But it's not an absolute.
So therefore it's not absolute. So you cannot have prior restraints on speech. The Supreme Court has been clear on that in the sense that...
And let's talk about that. Prior restraints on speech would be, for instance, if I was an editor of a newspaper, but I was required to go to you before publication to get your permission as a government before I could put out a story.
Right, exactly. So you can't So there's no sort of prior restraint in that sense. You can't censor films before they're released. You can't censor dramas or plays or theater before they're actually staged.
Now, this doesn't limit, or this doesn't stop self-censorship, which is its own problem.
Certainly.
But it does put up conditions by which I would not be required.
Absolutely. So which means that you can't you can't tell a newspaper, don't publish a defamatory article. So
Right.
they have the right to publish whatever they want to. But if that article is proven to be defamatory later, they might be liable to pay damages. And this again goes back to another famous U.S. Supreme Court judgment in New York Times versus Sullivan,
Yes.
which is sort of seen as the core preserver of the freedom of the press in many ways, because this was a case where an advertisement was run in support of Martin Luther King in the New York Times, and the advertisement made a number of allusions against the police department in Montgomery in Alabama, and they sued the New York Times for defamation, and they were awarded a huge amount of damages by the state court, in
Alabama,
and the Times ultimately took it up to the U.S. Supreme Court. And the Supreme Court said that with respect to public figures, when you're writing about public figures, the public figures need to show an additional element of actual malice. That is, not only that the speech was defamatory, but that the speech was made with actual malice. And this is a very important test, and it's a test that we've applied in India. The Indian Supreme Court has borrowed this from New York Times versus Sullivan to say that when you're speaking about public figures in India, you need to show that the speech, which is, even if it's defamatory, was made with actual malice.
With malintent. And so in this instance, the question is, in New York Times versus Sullivan, did the New York Times have malintent in publishing this piece or not? And the decision?
And the decision was they did not.
That's right.
That it was made in good faith,
Yes.
And that the press plays an important role in the preservation of democracy and in disseminating information, and that ultimately you need to protect the press as much as possible, and you can't prosecute them for these kind of acts. Whereas if they were speaking about a private figure, not the police department of Alabama, but a private citizen, and they were to make a speech, or they were to write something which was defamatory, malintention or malice would not matter.
And what if there was truth behind the statement?
Well, truth is considered an absolute defense in defamation, whichever part of the globe. I think in most parts of the globe, truth is an absolute defense to defamation.
Very good. So let's think about now, you were talking about other limits to freedom of speech, and we also have pornography is one, and specifically child pornography. There are limits on that. Obscenity. Obscenity not, again, more in something that is so considered so offensive that it would not be able to be placed in the public space. I can't go into your home without your permission and say what I want to. So there are limits on the place, as we discussed before. I can't go out into Gemini's Circle and start stopping traffic and to exercise my freedom of speech. There are limits on public safety or privacy, etc. Any other limits that that have been sort of
I think broadly
critical to the debate?
Broadly, many of these limits are predicated on one or the other of the theories of restrictions on free speech, either the harm principle, which was famously propounded by John Stuart Mill, which courts throughout have sort of tended to apply, or an offense principle. So the harm principle would mean that if your speech is likely to harm another person, then that kind of speech would be prohibited. Now, the thing, of course, here is that can you extend this harm principle to pornography? Some might argue you can, because pornography is harmful to women as a whole.
Specifically with children, the decision was that the existence of it would put children at risk.
So therefore the harm principle came into play there, and child pornography is therefore prohibited, whereas pornography isn't. But there are American feminist scholars like Catherine McKinnon who would argue that the harm principle should also apply to pornography in general, because it objectifies women, and the very objectification of women is harmful to is harmful to women as a whole, and therefore it's not protected speech. And this goes back to the idea of the First Amendment not protecting all speech, but it protecting a certain kind of speech. And you can also sort of look at this from the perspective of an instrumental value, right? If we look at speech as being important for the preservation of democracy, is pornographic speech really necessary for preservation of democracy? Some might argue it isn't, whereas others would argue that it has intrinsic value anyway. that if you start prohibiting pornographic speech,
Right.
then there is no real clear bright line
Everything
test which you
starts
can
there.
evolve to sort of where do you draw
Where
the
do you
line?
stop?
Yeah.
Exactly.
And it's the same with obscenity, I think. And the other, if we were to apply a more sort of, I would say a more stringent test of an offense principle, then anything which causes offense is likely to prove harmful to, or is likely to be seen as an exception to free speech. And again, I would like to cite one other scholar here, which is a New Zealand professor called Jeremy Waldron, who's written extensively about free speech, and he argues quite vehemently in favor of laws which in favor of hate speech laws, because he says that any kind of hate speech is harmful. And he takes the example of somebody having a placard or a poster which might say that Muslims go away, or African Americans get out of this country, or whatever, which is harmful to one or the other community. And that speech, he says, offends the dignity of those people, and therefore that's the value that requires preservation. And when speech is harmful to dignity, it cannot be protected. But this is sort of I think a larger philosophical debate, really.
Right.
And it's there are possibly very strong arguments on both sides. And at present, the American position would be in favor of more speech as opposed to less speech.
That's right. Now, you also at the top of the conversation, you were talking about the other clauses, and one of them, which we're not going to go too into detail, but is the freedom of assembly and freedom to petition. And I think that's so closely tied to freedom of expression and speech, because the idea is that I have the right to protest, or I have the right to speak to my government representatives with the expectation that they will respond. Now, that freedom of petition also has been interpreted different ways and over time. But any thoughts on that?
Yeah, I mean, I think when you talk about free speech or free expression, the Constitution, American Constitution, uses the word free speech, and then says specifically protects the freedom of the press and freedom to assemble peacefully. But if you look at free expression generally, I would think that it includes any form of speech, any form of political speech, and would certainly include forms of expression, which would include protests, which would include the right to assemble peacefully, would include the right to petition, which is specifically, again, protected. And, sorry.
I guess the difference is freedom to speak or freedom to be heard.
Right.
And so the assembly and the petition is focused more on the freedom to be heard.
Right.
Whereas some of the other areas that you were talking about, where my freedom to just voice my opinions or my values, but at the end of those clauses in the First Amendment, you have, and also I have the freedom to be heard by my government.
But I also think that in some senses, the definition of speech has possibly been extended to absurd lengths, because especially the protection of commercial speech.
Go ahead.
And the reason why I say that is, for example, election funding, where the idea that corporations can contribute or should be allowed to contribute as much as they want to whoever they want to is a form of speech. And I think there's a problem there. And when we start looking at the ability of corporations to spend as being an extension of free speech, it doesn't really fit into the larger values of the American First Amendment. At least, this is again an argument, because you have the judgment of the U.S. Supreme Court in Citizens United, which would argue to the contrary. So this is an argument to be made, and this is, again, a matter of debate. In India, perhaps we wouldn't see this as a form of protected speech, and in some other parts...
That commercial entities don't necessarily have the right for advertising, or... I mean, you also have this issue which you raised about from the very beginning, when the framers of the First Amendment were thinking about this, they were talking about false advertising, or we can talk a bit about disinformation, but persuading someone in a way that is false, that would have that could potentially do harm.
Right. Yeah. So, I mean, commercial speech, I think, therefore requires certain limitations. I'm not saying that it isn't entirely protected. It's obviously naturally protected in many senses, in the sense that you should be able to advertise your product, and that should be an extension of your free speech. But that right to advertise your product cannot extend to advertising it by spreading misinformation.
That's right.
Perhaps there cannot be a prior restraint on this, but if the speech is found to be misinformation or found to be malicious in some way, then there can be laws which are legitimately applied to prosecute those kinds of acts. And which is why I think, in some senses, possibly we look at the First Amendment and the protection of free speech as being far too extensive, and it shouldn't be as extensive as it is. At the same time, it should, in all senses, protect every form of political speech and every form of speech that is necessary, I think, for democracy to thrive. And in that sense, and in that aspect, America is a model in many ways for most countries, I would think.
Now, I want to talk a bit about your own background. You studied law, and then you had the opportunity to study journalism at Columbia University, and combining those things makes you, I think, a really great. It helps you have really wonderful insight on this topic of freedom of speech. What do you see in your own experience as the real difference between this concept, our First Amendment concept, versus your Article 19 freedom of expression?
Right. For starters, there are textual differences. But just to sort of look at my own experience in sort of being in studying at Columbia and being in the U.S., I was there roughly around the period also when Obama was elected the second time, and I could see how. I was there during the election campaign, and you could see what a difference free speech really made. What kind of a difference a free media makes. And of course, there can be doubts that are raised with respect to, is the media really free? Is the press really free? And to what extent, and what are the kind of power equations that make a difference? Naturally, power makes a huge amount of difference. I think the more money that you have, the freer you can speak. So I think we mustn't lose sort of this conception of how power and money especially can make a difference in your ability to speak freely, that your own economic and social status makes a difference when you're in your ability to speak freely. But I could see that there was this culture of respecting or of sort of guarding this right to free speech, which was immense in America and which remains, I think, immense in many ways. And that's a culture that many others are looking to adopt or have adopted in some sense, or at any rate endeavoring to adopt. And ultimately, I think, in that sense, the two constitutions, there are textual differences, but there are also cultural differences. As much as we see free speech as universal in value, there are cultural differences that make a difference in terms of how the Constitution actually works in practice. Right. Textually, the difference, I think, is that the Indian Constitution doesn't grant this sort of absolute right to free speech, which the American Constitution tends to do, at least textually. And it specifically places restrictions.
That's right.
Where restrictions in the interest of defamation and contempt of court, of
sedition.
No, sedition isn't specifically written into the Constitution, but it's seen as an extension of one of these limitations that are written in the Constitution itself. But we've borrowed and looked at American jurisprudence extensively. As I said, New York Times versus Sullivan is a judgment that we apply. Brandenburg versus Ohio is heavily cited by the Indian Supreme Court. You had a judgment recently, a few years back, which struck down Section 66A of the Information Technology Act in India, which sort of had prohibited any kind of offensive speech online, where the Supreme Court looked at American judgments and applied those American judgments in an Indian context. So therefore, because these values are largely universal in nature, I think there's great scope for us to look at American jurisprudence, and perhaps there might come a time when American courts might also look at jurisprudence from other parts of the world. Justice Stephen Breyer, who's on the U.S. Supreme Court, often tends to do that, perhaps to the chagrin of some of the other judges on the bench, but he's looked at global constitutions and how they work to see if they can be applied in the American context. So that's and this comparative debate, not just between the American and the Indian Constitution, but between America, India, various different European constitutions and across the world, is important, I think, for us to learn really from each other and how it works.
I was interested in speaking with you earlier about, we, as an American, when we hear freedom of speech, freedom of expression, we feel that we have that very much enshrined in our First Amendment. And when other constitutions are formed and they adopt those important rights, we think that they're drawing from us. But Japan, you had mentioned, also Ireland.
Well, when the Indian Constitution was being framed, we had many different models before us, right? We had the American Constitution. The Japanese Constitution was just being drafted, and America had a big influence on that. So we were able to look at those. There was the case of the constitutional advisor in India, B.N. Rao, who traveled to America, who met Justice Felix Frankfurter, who advised him against the due process clause, for example. Okay. So there were certainly experiences that were drawn on. There was the text of the American Constitution did make a difference in terms of how the Indian Constitution was being drafted. But I think as much as the text itself, it's also how the courts have applied it in terms of how the American Supreme Court has interpreted it, because a lot of this, I think ultimately is an interpretive exercise. Yes. These are not terms that are these are terms of art, but at the same time they require interpretation, and we need to interpret them in accord with the changing times. Yes. and look at them as sort of speaking to the intelligence, as I said, of a future day, where you look to the future and see how to interpret these clauses in a manner that will bring about, I think, justice and at the same time preserve equality and liberty.
Now, you hit on it there, speaking to looking to the future. You and I are both here, and thank you so much for being with us. As part of the U.S.-India Comparative Constitutional Debate Project that we are running with the U.S. Consulate here in Chennai. And what do you think about the young people who are coming up in India, the young lawyers and some of the political scientists, social scientists? What sort of lessons do you think that they can pull from this project?
Well, I think the project is a great initiative, and I must congratulate you on putting it in motion, and I'm looking forward to how it pans out, and I'm sure it'll be a resounding success. And I think the students will have a lot to take away from it, because the idea is to get people talking about these things, right? Yes. And a lot of students these days are very, very well informed. It's not that they but they sort of have that grounding, I think, and this, again, it speaks to this development of a constitutional culture, I think. But the idea is to get them speaking, to try and look at things analytically, to see how the American Constitution works, to see how it works in contradistinction to the Indian Constitution, to see what works better in different kinds of circumstances. We spoke of hate speech, for example. This is a great debate to be had, right, in terms of what works well, or obscenity laws, or pornography. All of these
spinning into modern, very contemporary issues like bullying or trolling, and where that relates.
Absolutely.
And I think that actually a lot of the students who will be involved in this project probably have better insight or greater insight into some of these issues and how they can be handled in both in India and in the United States. So we're looking forward to having you and some other American legal scholars and people who are also coming as scholars from across India be involved with this. I would ask a question. So you did your legal studies here in India. What resources did you draw upon? Obviously, did you have mentors? I make a pitch to everybody to please come to, if possible, the American Center at Gemini Circle here in Chennai, because we have all kinds of library books. We have a wonderful library with books on the Constitution of the United States or comparative constitutional resources, and actually we have one of the largest holdings of American studies resources in all of South Asia. Mm-hmm. So we're pretty proud of that. So we welcome people to come and use our space. But what resources, if you were going to be participating in this debate competition, what resources or tools would you recommend for some of these students?
Right. I mean, there are a number of. I mean, you can't obviously be reading a number of textbooks, right? And right? It's difficult to
don't go read all the textbooks.
Yeah. And so I could obviously cite a number of textbooks here, but I think there's the SCOTUS blog, which is a great resource for American Supreme Court judgments.
SCOTUS blog.
Yeah.
Okay.
And there are various different other online resources which can be useful. There are blogs which write about Indian Supreme Court judgments. There's a blog run by Gautam Bhatia, who's a lawyer here in India. There's a Law and Other Things blog, which speaks about Indian Supreme Court judgments. Okay. So perhaps these will give an idea of the kind of contemporary issues that are at play right now.
Great.
And they in turn will be able to give resources which take you to go on a larger study, I think.
Okay. Thank you so much for talking about the history of the First Amendment and from 1791 up to 2019.
So it's been my great pleasure. Thanks for having me.
We're so delighted.
Thank you.
Thank you so much.
Hello, I'm Suhrith Parthasarthy. I'm a lawyer. I practice here in Chennai at the Madras High Court. I'm greatly looking forward to the constitutional law debate which the U.S. Consulate here in Chennai has put together, and I hope all of you will come and participate in large numbers. It's going to be exciting, and I'm sure you're going to learn a lot over the course of the event. Thanks very much.
Welcome back. The conversation you just watched highlighted the right to freedom of expression guaranteed by the First Amendment. For students preparing for the comparative U.S.-India constitutional debate, the details contained in this video will provide you with an opportunity to compare how both our constitutions protect free speech.